Okay, let's unpack this. Picture a courtroom. It's a cold, damp winter afternoon, July 2012, down at the Waverley Local Court in Sydney. A man steps forward.
Hmm.
He looks every bit the part, dressed sharply, carries himself with that air of a seasoned barrister. He announces his appearance, ready to represent his client in what seems like a pretty standard AVO hearing and apprehended violence order.
Right, routine stuff on the surface.
Exactly. But underneath that confident exterior, he's hiding this, well, devastating secret. This man, John Bernard Costigan, known to many as Jack, had actually been secretly banned from practicing law.
Banned, like completely.
Completely. His license, his permission slip to be a lawyer, it had been revoked months earlier. Yet here he was, standing right there before a magistrate, bluffing his way through, attempting this incredibly reckless and frankly audacious deception.
Wow.
This isn't a scene from some TV show. This moment in Waverley Court is terrifyingly real, and it marks the dramatic public beginning of John Bernard Costigan's final, swift descent from the legal profession.
And what's truly captivating about this story and, ultimately tragic, is how that single act, that brazen appearance in court without a license, it wasn't really the cause of his downfall. It was more like a symptom.
A symptom.
Yeah, a symptom of years, literally years of mounting financial pressures, hidden ethical lapses, and these profound betrayals of the fundamental trust placed in him. Trust from clients, trust from the court.
Exactly right. And that's what we're diving deep into today. This isn't just recounting facts from court documents. It's the true, complex, and ultimately heartbreaking story of Costigan's undoing. It's a tale that weaves together trust betrayed, desperate lies, and the inescapable justice that eventually caught up with him. And for you, the listener, especially if you're maybe thinking about a career in law or perhaps just starting out, this isn't just history.
No, it's vital.
It's a critical, real-world cautionary saga about ethics, accountability, and the absolute non-negotiable necessity of integrity in the legal profession.
We're going to use the source material you've provided.
Yeah.
These detailed judgments from the NSW Supreme Court and the NSW Court of Appeal, plus some insightful legal commentary, kind of as our guide,
Yeah.
We'll pull out the absolutely critical moments, the specific rule breaches that were, fatal to his career, and the severe consequences. And we'll frame it all to really highlight the incredibly high stakes involved in being a lawyer. Think of it maybe as a legal thriller that actually happened.
But with real lessons.
Exactly. Profound, urgent lessons embedded in every single twist and turn of this story.
Okay, let's start by introducing some of the key players in this unfolding legal tragedy. At the very center, of course, is John Bernard, Jack Costigan himself.
Jack Costigan.
Admitted as a barrister way back in 1989. So, he'd been practicing for over 2 decades. For a good chunk of that time, he was seemingly a respected member of the bar.
Looked the part, as you said.
Absolutely.
Yeah.
But the sources make it starkly clear that behind that professional facade, his career was, deteriorating. It seems fueled by mounting financial troubles and this growing pattern of professional misconduct.
Then you have the clients.
Yeah.
The people who are caught in the devastating wake of his actions.
Yeah.
You've got Ross Mercer and Janine Mercer. They were directors of a company called 10 Green Bottles, Pleady Ltd. They paid Costigan a pretty substantial sum, actually over $25,000.
25 grand, wow. Up front.
Up front, yeah, for legal work related to their company. Money explicitly given for services he was supposed to perform.
But never did.
Never did, tragically. And Mr. Mercer's subsequent complaint to the Bar Association was one of the crucial triggers, really, that kicked off the formal disciplinary process against Costigan.
And the story gets even more distressing somehow with the family of Professor Noel Dan and his daughter, Carrie Louise Dan.
Oh, this part is heartbreaking.
Professor Dan, a distinguished neurosurgeon, right, facing a difficult legal matter for his daughter, places immense trust in Costigan.
Huge trust.
He entrusted him with a staggering amount, $82,500. $82,500. Basically, the sources say his life savings.
Life savings, intended specifically for Carrie Louise's legal costs.
Just imagine the vulnerability there. Handing over that kind of money for such a critical purpose to someone you believe is a reputable lawyer.
Precisely. And this money was absolutely not Costigan's to treat as personal income, you know? It was given for a specific legal matter. It had a purpose.
Okay, now turning back to that dramatic scene in Waverley Court, we have Magistrate Ellen Millage. She was the magistrate presiding over those AVO proceedings where Costigan made that illegal appearance.
Right. She was the one he stood up in front of.
Yeah. The case itself involved former spouses, and that they're referred to in the court documents with suppressed identities, MH and MSS.
To protect their privacy, right?
Exactly. MSS was the person Costigan claimed to be representing that day, and MH, who was the applicant in the AVO, he actually became a key witness later.
So he saw Costigan there.
Yes. His observations and subsequent evidence were crucial in helping to expose Costigan's unauthorized practice before the court. The suppression orders, it's important to note, were made to protect their privacy in an unrelated family law matter that just unfortunately got tangled up with Costigan's professional downfall.
Right, okay. And then there's the regulatory body itself, the NSW Bar Association. They were central, obviously, tasked with investigating and prosecuting Costigan's misconduct.
And involved in their oversight and the legal proceedings that followed were people like Helen Barrett. She was the Deputy Director of Professional Conduct for the Bar Council at the time.
So she would have been involved in communications with Costigan.
Yeah, the sources indicate she was involved in important communications regarding his obligations and the bar's investigations.
And in the actual legal battles, the court cases to stop Costigan and ultimately remove him from practice, the Bar Association needed strong representation.
They did. They were represented by Ms. C.A. Webster, S.C. That SC stands for Senior Counsel, a mark of seniority and real experience at the bar.
Right, a top barrister.
And she appeared for the NSW Bar Association in both the Supreme Court application for that urgent injunction and the final disciplinary proceedings in the Court of Appeal. Very skilled counsel, by all accounts.
The Bar Association would also have needed solicitors, right, to handle the paperwork, the procedural side.
Yes, they engaged Hickson's lawyers as their solicitors, specifically for the Supreme Court injunction proceedings.
Okay.
Then, when the matter reached the highest court for disciplinary matters, the Court of Appeal, the records show, P. Beasley, solicitor, appeared for Costigan, who was the respondent in that case.
So Costigan had representation at that final stage.
It appears so, yes. Mr. Beasley was listed as his solicitor. Although, it's worth noting, the sources indicate Costigan himself was largely unresponsive to the allegations overall and didn't file formal responses, particularly in that initial Supreme Court action where the injunction was sought.
Unresponsive. That often doesn't help.
No. And the judges who ultimately presided over these critical proceedings, you had Justice David Garling. He heard the Bar Association's urgent application for the injunction in the NSW Supreme Court.
Right, the injunction hearing.
And then the final decisive judgment, the one that led to Costigan being struck off, that came from a panel of 3 justices in the NSW Court of Appeal.
A full bench.
Yes. Justices McFarlane, J.A., Gleason J.A., and Sackville A.J.A. That J and A.J. denote their positions as justices of appeal, the court with that inherent power over lawyers' conduct and fitness to practice.
And these courts, in deciding Costigan's fate, they wouldn't just be making it up as they go along, right? They'd look at previous cases.
Absolutely. The judgments in Costigan's case frequently refer to important legal precedents, previous landmark cases that establish the standards for lawyer conduct.
Setting the bar, so to speak.
Exactly. They mention judgments from prominent judges like former Chief Justice Spiegelman and other key justices of appeal like Mason P., McCall J.A., Scheller J.A., Beasley J.A., Hardy J.A., and Reynolds J.O.
Big names in NSW law.
Very much so. From foundational cases like NSW Bar Assoc v. Cummins, NSW Bar Assoc v. Hammond, NSW Bar Assoc v. Perry, Prothonotary v. Kearns, Prothonotary v. McCaffrey, Law Society of NSW v. Foreman, Meadling v. the Law Society of NSW. The fact that Costigan's conduct was compared to these established authorities really underscores how his misconduct fell squarely within well-defined categories that courts consistently deem absolutely incompatible with practicing law.
So it wasn't a borderline case.
Not according to the courts, no. Okay, that gives us the landscape, the key players involved in this whole drama. But to really understand how a barrister admitted back in '89 ends up standing unlicensed in Waverley Court decades later, we need to look at the backstory.
Yeah, the cracks in the foundation.
The cracks that were quietly forming in Costigan's foundation long before that public moment of deception.
It's quite a contrast, isn't it? Because Costigan held a practicing certificate continuously from his admission in 1989 right through until April 2012.
Yeah, over 20 years.
On the surface, that looks like a stable, decades-long career. But the sources, when you dig into them, reveal a much more turbulent reality just beneath that surface.
And a huge part of that turbulence was mounting financial pressure. He was clearly struggling deeply with debt.
Yeah, the pattern noted in the sources is really quite concerning. Bankruptcy petitions were filed against him not just once, no, multiple times over several years, in 2008, 2010, and again in 2011.
Wow.
And these weren't from, minor creditor either. They are from various parties, Mr. Rogerson, Lion Finance, acting for a school, SEEGS, Darlinghurst, CCM Travel, acting for Citigroup. Suggests pretty widespread financial difficulty.
Okay, and this financial distress, this isn't just a personal problem for a lawyer, is it?
Absolutely not. That's critical in the context of professional obligations. Under the Legal Profession Act, being served with a bankruptcy petition isn't just, bad personal news. It's what's legally termed a show cause event.
A show cause event, what does that mean practically?
It means the lawyer is under a strict legal duty, not optional, a duty to notify their professional body, the Bar Association in this case, within a very short time frame. Just 7 days.
7 days, that's quick.
It is. And then they have 28 days to provide a written statement explaining why, despite this significant event, they believe they remain a fit and proper person to hold a practicing certificate.
Right, they have to justify why they should keep practicing despite being potentially bankrupt.
Exactly. It's about transparency and protecting the public.
And Costigan, he failed to do this.
Repeatedly. The sources detail his failure to disclose multiple bankruptcy petitions. Not just the ones in 2010 and 2011, but others going back years before the Bar Association finally discovered this pattern in November 2011, like one from Mr. Rogerson in 2008 and another in early 2009.
He just didn't tell them.
Didn't tell them. Kept it hidden.
So when the Bar Association finally confronted him about these hidden financial problems and his failure to disclose them back in 2011, what was his excuse?
Well, his excuses were, frankly, pretty unconvincing, according to the court. He claimed he suffered from an undiagnosed mental illness and that he, quote, did not know he had to report these events.
Didn't know, after being a barrister for over 20 years.
Exactly. And crucially, the sources highlight that the Bar Association had explicitly reminded him of his disclosure obligations regarding show cause events just months earlier, in March 2011. This was specifically after an earlier incident from 2009 had come to light.
So they literally just told him about this rule.
Yes. So the court didn't really buy the "I didn't know" argument. It pointed towards a pattern of either, willful disregard or, perhaps more charitably, of still unacceptable, a profound level of recklessness concerning his professional duties.
Okay, so it wasn't just financial issues and hiding them. The bar had already flagged concerns about his health and well-being even further back.
That's right. The concerns weren't new in 2011. Since 2007, there had actually been medical conditions imposed on his practicing certificate.
Conditions on his license? Why?
This came after a conviction for a tax offense, failing to comply with tax laws under Section 8G of the Tax Administration Act.
The tax conviction? That's serious for anyone, let alone a lawyer.
It is. And his explanation for that tax conviction, and also for failing to disclose it on his application to renew his practicing certificate around that time, also leaned heavily on health claims.
What did he say?
He described experiencing anxiety, panic attacks, a fear of flying consistent with panic disorder, with agoraphobia, and even PTSD. He argued these conditions led to what he called errors of omission, like forgetting or failing to put the tax conviction on his renewal form.
Errors of omission.
Then, by 2009, the bar's concerns had expanded to include potential issues with alcohol use.
Alcohol, too.
Yes. The Bar Association took formal steps then, ordering a medical examination under the Act. This is where Dr. Alex Wodak, an addiction specialist, evaluated him in 2010.
And what did Dr. Wodak find?
Well, at that specific point in time, Dr. Wodak concluded that while Costigan did have an alcohol problem, it hadn't, in Dr. Wodak's view back then, progressed to the point where it demonstrably impaired his work sufficiently to justify removing him from practice at that stage.
Okay, so the bar knew about potential alcohol issues, but were told it wasn't impacting his work severely enough yet.
Correct. Based on that assessment, the bar initially tried a supportive approach. They imposed conditions on his practicing certificate requiring him to get treatment, provide regular reporting on his progress. They allowed him to continue practicing, hoping, that he could manage these challenges with support.
But the problems didn't go away.
No, they persisted. Further conditions became necessary in 2011. This was after new criminal charges emerged from incidents back in 2009 specifically, charges for drink driving and driving while disqualified.
Drink driving and driving while disqualified, while he was already under scrutiny.
Yes. It showed the problems weren't being resolved.
And speaking of driving and hidden problems, the sources also mentioned other past driving and traffic convictions he hadn't told the bar about promptly.
That's right. Another layer to the non-disclosure pattern. Between 2002 and 2007, he had several of these.
Like what?
There was a low-range PCA that's drink driving conviction in 2007. Charges for negligent driving and other offenses also in 2007. Driving with a canceled license back in 2002. And a high-range PCA, a serious drink driving offense also in 2002, which he only belatedly disclosed years later in 2006.
High-range PCA. Wow. And he didn't report these when they happened?
No, not in a timely manner as required. The rules back then under the Legal Profession Regulation and later the Act were clear. Lawyers had to notify the bar of such convictions.
And failing to notify, that's misconduct in itself.
Yes, it constituted unsatisfactory professional conduct. Now, the court acknowledged that these specific driving convictions, viewed in isolation, probably wouldn't typically lead to someone being struck off.
But their significance lay in the pattern they revealed. They demonstrated this consistent disregard for basic legal and civic obligations. And crucially, his repeated failure to report them just reinforced the picture of a lawyer lacking candor, lacking transparency with his professional regulator. It added weight to the argument that he habitually hid problems rather than facing them.
So the picture emerging from this backstory is just, wow. It's a lawyer under severe long-term financial strain with underlying health issues possibly playing a role, maybe alcohol issues too, and a clear established pattern of failing to be upfront and honest with the very body responsible for overseeing his fitness to practice.
Exactly. The foundation was deeply unstable, wasn't it? Even before things escalated into the really catastrophic breaches.
Yeah.
This background is so crucial because it provides context, though. Let's be absolutely clear. Certainly not justification for the truly devastating ethical breaches that followed. It highlights how unchecked personal and financial problems can just corrode professional integrity, especially when it's compounded by a lack of transparency.
And those devastating breaches include what is arguably the most serious misconduct you can commit short of, a criminal conviction for theft itself. The absolute betrayal of trust involving client funds.
This is where Costigan crossed a line that is almost universally fatal to a legal career. No gray area here.
When did this happen?
In late 2011 and early 2012, precisely when he was grappling with those severe financial pressures we talked about, the bankruptcy proceedings. He took money from two different clients under circumstances that flew directly in the face of the incredibly stringent rules governing barristers and client funds.
Okay, let's revisit the Mercer situation first. Ross Mercer, acting for his company, 10 Green Bottles.
Yes. In December 2011, Mr. Mercer paid Costigan $25,410 for legal work. The sources are specific about how the money was transferred. Mr. Mercer made a direct deposit into a bank account nominated by Costigan.
Just a regular bank account, not like a special trust account.
Exactly. And here's the critical point. This was not a designated trust account. Barristers in New South Wales operate under very, very strict rules regarding client money, especially money paid in advance for fees, which this was.
Okay.
Under Section 252 of the Legal Profession Act, barristers are generally prohibited from receiving what's called trust money, money held on behalf of a client, unless they fit a very specific limited exemption.
There's an exemption.
Yes, outlined in the regulations like Clause 106A of the Legal Profession Regulation 2005, which applied to barristers taking clients directly without a solicitor. But even if you qualify for that exemption,
there are conditions.
Huge conditions. The exemption requires the money to be deposited into a designated account that is clearly identified as being in connection with the barrister's law practice. And absolutely critically, that money must be held untouched until a proper bill is issued for work actually done, or the money is refunded to the client if the work isn't done.
Untouched, like you can't just dip into it.
Cannot dip into it. It's not your money until you've earned it and billed for it.
And Costigan, he completely ignored those rules with the Mercer money.
Completely. Utterly disregarded them. What happened? Within days, literally days of receiving that $25,410, Costigan withdrew the vast majority of it, $23,000.
$23,000 straight away. Where did it go?
He transferred it directly to his personal credit card account.
His credit card?
Yes, to pay off his own debts. And the sources note that after this, he essentially went to ground, became unresponsive, emails unanswered, the legal work the Mercers had paid for simply never done. By the end of that same month, December 2011, their money was gone, absorbed into his personal finances, and their lawyer was unreachable.
Gone. Wow. And then we have the even larger sums from Professor Dan.
Yes.
The situation with Professor Noldan is, as I said, heartbreaking, just due to the sheer amount involved and the purpose of the funds.
Remind us of the timeline.
Between December 2011, so around the same time as the Mercer issue started, and February 2012, Professor Dan paid Costigan a total of $82,500.
$82,500.
For his daughter, Carrie Louise's legal matter. This money was explicitly meant to cover legal fees for her case. The payments came in two significant chunks, $55,000 just before Christmas in 2011, and another $27,500 in early 2012.
And the sources point out something deeply concerning about the account where that first payment went, didn't they?
They do. It's a really telling detail. When that initial $55,000 was deposited into Costigan's nominated account again, not a proper trust account, the account was actually overdrawn at the time.
Overdrawn, so he was already in the red.
Yes. Professor Dan understandably wouldn't have known this, but it speaks volumes about Costigan's desperate financial state at that moment. And it highlights that the money wasn't being held safely. It was immediately needed just to cover his existing debts, not held aside for future legal work.
And like the Mercer funds, this huge sum, $82,500, it just vanished quickly.
Exactly the same pattern. Costigan treated this large sum of Professor Dan's life savings as if it were his own personal slush fund. The sources clearly show that within days of receiving the money, he was using it to pay off his credit card bills.
Again with the credit cards.
Yes, and he even made purchases overseas during a trip he took in January 2012. There's a specific detail about one check for $13,750 from Professor Dan.
What about it?
It was deposited directly into Costigan's credit card account in February 2012, not even into his regular bank account first. And another check from Professor Dan was actually signed over to a third party, someone completely unrelated to the daughter's legal matter.
Just gave it away?
Essentially used it as cash.
Oh.
By mid-2012, virtually none of Professor Dan's $82,500 remained in any account that could remotely be considered appropriate for holding client funds. It was gone.
So he didn't just fail to follow the technical rules about trust accounts. He actively took the money and spent it on himself.
Precisely. He didn't just flout the requirements of the Legal Profession Act and the regulations. He acted in complete opposition to them. He never deposited the funds into a proper designated account under those limited exemption rules. He never rendered a single bill for the services he was supposed to provide to either the Mercers or Professor Dan's daughter. And he certainly never refunded the client's money when the work wasn't done.
No refund, no work, no money left.
Nothing. As the court documents and commentary starkly describe it, he quietly siphoned the money to cover his own debts. This wasn't some complex misunderstanding of accounting rules. It was, in effect, the misappropriation, essentially theft of client funds.
And the court's view on this specific conduct, it was uncompromising, wasn't it?
Absolutely. Crystal clear. The court found that his conduct in dealing with these funds wasn't just negligent or careless. It showed a reckless disregard of his clear, fundamental obligations under Section 252.
Reckless disregard, that's strong language.
It is. And critically, they went further. They found that applying the money to his personal needs, paying his credit cards, funding his travel before doing any work or issuing a bill was dishonest.
Dishonest. That's the finding that really bites, isn't it?
It's a finding of profound significance in disciplinary proceedings. And the court explicitly stated that this dishonesty was not excused by his financial pressure. The fact that this happened with two different clients over several months, precisely when he was under severe financial strain, led the court to conclude that he deliberately, consciously prioritized his own desperate financial needs over his fundamental ethical duty to protect his client's funds.
How does this kind of conduct, outright misuse of client money, stack up against other disciplinary cases? Is it pretty much a guaranteed path to being struck off the roll?
Almost without exception, yes. It's about as serious as it gets in professional conduct terms. The sources make it absolutely clear that Costigan's actions here align perfectly with a long and consistent line of legal precedent in NSW and elsewhere. Cases where the misuse, misappropriation, or any dishonest dealing with client funds has led to permanent removal from the role of lawyers.
Can you give some examples?
Sure. The judgment references cases like NSW Bar Association v. Power from 2008, Law Society of NSW v. Foreman from 1994, NSW Bar Assoc v. Hammond from 1999. They all underscore this core principle.
And what is that core principle? Why is it treated so severely?
The rationale is fundamental to the whole system. Lawyers are entrusted with vast sums of money, confidential information, people's futures, essentially. They act as fiduciaries. That means they have a duty to act in the best interests of their client, like a trustee.
Abusing that trust, especially by stealing or misusing their money, is seen as the ultimate betrayal of the lawyer's role.
It shatters the whole basis of the relationship.
Completely. It's considered professional suicide regardless of the lawyer's personal circumstances, including financial strife or health problems. The court in Costigan's case even echoed the words of former Chief Justice Spiegelman from that leading case, NSW Bar Assoc v. Cummins.
What did Chief Justice Spiegelman say?
He highlighted how, quote, many aspects of the administration of justice depend on the trust by the judiciary and/or the public in the integrity of lawyers. Stealing or misusing client money utterly shatters that essential trust.
Okay, so the misuse of funds was clearly a massive issue, but the sources also touched on inadequate costs disclosure. Was that just a minor technical point, or did it contribute to the overall picture of misconduct?
It certainly contributed. While perhaps less grave in isolation than outright misappropriation, his cost disclosure letters, the documents lawyers have to give clients, explaining fees to both the Mercers and Mrs. Dan, were found to be inadequate. They didn't meet the requirements under the relevant provisions of the Act and the barrister's rules at the time.
What was missing?
He failed to include key details that were legally required. Things like a clear basis for calculating his fees, properly advising clients of their rights, like their right to negotiate fees or receive itemized bills, providing realistic estimated total costs, and other essential information designed to ensure transparency.
And the sources suggest he was particularly misleading in the letter to the Mercers.
Yes, the court specifically noted that. In the letter to the Mercers, Costigan apparently misrepresented that he was effectively taking on the role of both solicitor and barrister, which blurred the lines. And significantly, he wrongly suggested that receiving funds in advance was a necessary prerequisite for him to do any work or appear in court.
Which wasn't true.
Not strictly correct under the rules, especially given the restrictions on barristers holding funds. The court saw this as him basically exploiting the direct access arrangement where a client goes straight to a barrister, potentially confusing clients who might not have fully understood the very strict, limited circumstances under which barristers were permitted to receive and hold money directly back then.
So it wasn't just a paperwork error. It actually helped set up the situation where he could get his hands on the money improperly.
That seems to be the implication, yes. It facilitated the very situation where he was holding funds in a way that ultimately allowed him to misuse them. It added to the picture of someone not adhering to the rules designed to protect clients.
Right. So you have this pattern building, financial distress, hidden problems, serious misuse of client funds, inadequate disclosure. What actually happened with his practicing certificate after these client complaints surfaced? Did the bar act quickly?
Yes. Once the complaints, particularly the Mercer complaint, came in and the investigation progressed, his certificate was put under immediate scrutiny and then ultimately revoked.
What was the timeline?
On 26 April 2012, the Bar Association suspended his practicing certificate. This was an initial suspension for 56 days, and it seems primarily triggered by this complaint lodged by Ross Mercer about the $25,000.
So it's suspended first.
Yes, but then things escalated quite quickly. On 21 June 2012, his certificate wasn't just suspended anymore, it was canceled entirely by the Bar Association.
Canceled? Why the upgrade from suspension?
The cancellation was specifically made under Section 67 of the Act. This section deals with show cause events. Remember those bankruptcy petitions he failed to disclose? Well, another bankruptcy event had occurred in March 2012, and he had apparently failed to show cause, basically. Failed to provide a satisfactory explanation to the Bar Council why he remained fit to practice despite this latest event. So they canceled his ticket.
Did he fight the suspension or the cancellation? Did he appeal?
No. The sources are very clear on this. He did not appeal either the suspension or the subsequent cancellation. Furthermore, he did not apply to renew his practicing certificate for the next period, which started on July 2012.
So he knew he was out.
He was acutely aware of his status. He couldn't possibly not know. The sources even mention he had sent an email to the Bar Association explicitly stating he had no intention of renewing his certificate and simply wished, quote, only to be left alone.
Only to be left alone.
So from 1st July 2012 onwards, John Bernard Costigan was categorically, legally, no longer entitled to engage in legal practice in New South Wales. That's under Section 14 of the Act. He was off the books.
And yet, despite knowing he was banned, knowing he had no license, knowing he'd told the bar he wouldn't practice, he chose to keep practicing anyway.
Yes, astonishingly.
This brings us right back to that shocking scene at Waverley Local Court.
Exactly. This is where his defiance moved beyond just hiding problems or misusing funds privately. This was active, public, blatant flouting of the law and deception of the court itself. On 26 July 2012, just weeks after his certificate was formally canceled, and he knew, absolutely knew, he couldn't practice, he walked into Waverley Local Court for that AVO case involving MH and MSS.
And he didn't just, sit quietly in the back row hoping no one would notice him.
Not at all. He strode right up to the bar table, announced his appearance for the respondent, Mrs. S., directly to Magistrate Millage, and he deliberately, actively did not disclose the crucial fact that he was unlicensed.
Lied by omission.
A massive lie by omission. He didn't even take the step of seeking leave from the court to appear, which a barrister might sometimes do in the local court if there isn't an instructing solicitor present, but which would be entirely improper and impossible for someone who isn't even a barrister at all anymore.
Right.
He just proceeded as if everything were completely normal, interacted with the magistrate, indicated he would go and speak to his client. It was a complete masquerade, designed purely to deceive everyone present, the magistrate, the other party, the court staff.
And his audacity didn't stop there. It continued.
Incredibly, yes.
Yeah.
When the ABO case came back before the court about a month later, on 30 August 2012, Costigan showed up again.
Still pretending.
Still pretending. And the sources suggest that by this point, his supposed former client, Mrs. S., may have actually obtained representation from a genuine legal aid solicitor.
So there was a real lawyer there for her.
Possibly. Yet Costigan was still there, hanging around. He was seen lurking in the foyer of the courthouse. He then actually approached MH, the opposing party, the applicant in the AVO matter, and proceeded to scold him about not having filed a witness statement on time.
He confronted the other side.
Yes, acting precisely as if he were still Ms. S.'s counsel on the case, giving the other party directions or admonishments. Utterly inappropriate and, of course, completely unauthorized.
And then came that truly bold-faced lie directly to the court staff.
Ah, yes. This detail is particularly damning because it wasn't just an omission. It was a direct, verifiable falsehood. He went up to the court counter and tried to get the court file for the AVO matter from a member of the registry staff.
Just asked for the file.
Yes. When the clerk, likely seeing him without the usual accompanying solicitor, or perhaps just sensing something wasn't quite right, asked him who he was, Costigan lied directly.
What did he say?
He stated, quote, "Yes, I'm the barrister in this matter. I am briefed by the duty solicitor." And he even pointed towards a genuine duty solicitor who happened to be present in the court precinct that day, implying association.
He implicated the duty solicitor. Wow. Thankfully, the court clerk didn't just hand over the file.
No, thankfully they didn't. The clerk's vigilance, or maybe just adherence to procedure, prevented potential further damage or confusion. The clerk sensed something was amiss, didn't give him the file, and advised him the matter needed to be raised properly in open court. This incident, witnessed not only by the court staff but also by MH, became crucial, undeniable evidence of his deliberate deception and continued unauthorized practice.
He even kept acting like a lawyer through emails after these court incidents.
Yes, the deception continued even outside the courtroom. The sources note that as late as October 2012, well after these court appearances, he was still sending emails to MH regarding the ongoing AVO case.
What was in the emails?
He was attaching documents, like a client statement, and legal submissions related to the case. Now, interestingly, he apparently included a disclaimer in those emails, claiming he wasn't acting as a barrister or providing legal advice.
But the court didn't buy that.
No. The Court of Appeal later looked at these communications and found that, despite the disclaimer, they bore all of the hallmarks of practicing as a barrister. He was clearly continuing to provide legal services, draft documents, and hold himself out as involved in the matter in a legal capacity, despite knowing perfectly well he had absolutely no right to do so.
The severity of practicing without a valid certificate, it feels like something that should be common knowledge for any lawyer, yet he just did it anyway, repeatedly and brazenly. Why is this specific act considered such a grave offense in the eyes of the law and the profession?
Well, practicing law without a practicing certificate, which is explicitly prohibited by Section 14(1) of the Legal Profession Act, isn't just a minor rule violation or a technicality. It is, quite simply, illegal conduct.
Right, it's against the law.
And in Costigan's case, the evidence overwhelmingly showed it was a knowing, deliberate, blatant violation. It represents a fundamental disrespect for the law itself, the very system he swore an oath to uphold. And it shows contempt for the entire regulatory system established specifically to protect the public from unqualified or unethical practitioners.
How does it affect the courts?
When a lawyer appears before a court, the bench, the opposing counsel, the court staff, and the public are entitled to assume they must be able to assume that the person is properly licensed, regulated, insured, and subject to ethical rules. Costigan's actions completely undermine that foundational trust. It implied this dangerous belief that the rules, the law, just didn't apply to him.
And the risks to the clients involved, or even former clients, like SS in this case, they must be huge.
Enormous. An unlicensed individual purporting to act as a lawyer typically has no professional indemnity insurance. That means if they make a mistake, a negligent error that harms the client has no recourse, no compensation fund to claim against.
No safety net.
None. Plus, they aren't subject to the ongoing professional standards, the continuing legal education requirements, or the binding ethical rules that licensed practitioners must adhere to. Their involvement can potentially compromise the validity or fairness of the legal proceedings they participate in, opening the door for appeals or challenges later on.
So it taints the whole process.
It absolutely does. This deliberate, dishonest, and audacious conduct appearing in court, lying to staff, sending legal documents while unlicensed, was found by the Court of Appeal to be professional misconduct of the highest order. Both under the traditional common law definition conduct considered disgraceful or dishonorable by professional peers, as defined in cases like Mealing and McCaffrey, and also under the specific definition in Section 21 of the Act. It demonstrated beyond any doubt that he lacked the fundamental character, honesty, and trustworthiness essential to be a member of the legal profession.
Okay, so the Bar Association was faced with this situation. A barrister with a history of financial troubles and non-disclosure who had seriously misused significant client funds and was now openly and illegally practicing law despite being banned. It's a pretty dire picture. How did the legal system respond formally to stop this and address his overall conduct?
The NSW Bar Association, acting in its crucial role as the regulator responsible for maintaining the standards of barristers and protecting the public, took decisive legal action through the courts. They initiated two main sets of proceedings against Costigan.
Two sets. What were they?
The first was an urgent, immediate step aimed at stopping the ongoing harm. That was an application to the Supreme Court for an injunction.
A court order to stop him doing something.
Correct. Recognizing the clear and present danger to the public from him continuing to practice illegally, the Bar Association filed a summons in the NSW Supreme Court on 8 November 2012. They sought an injunction under a specific power in Section 720 of the Legal Profession Act.
What does Section 720 allow?
It allows the professional body to seek a court order to legally restrain someone from engaging in legal practice if they're doing so without a valid certificate. This was essentially an emergency measure by the bar. Given his behavior in Waverley Court back in July and August, they had very strong grounds to believe he posed an ongoing risk and would likely continue his illegal practice, if not explicitly stopped by a formal court order.
Right, they needed to shut it down immediately. Who were the legal teams and the judge involved in this specific injunction proceeding?
The case was heard in the NSW Supreme Court by Justice David Garling. Costigan himself was served with the court documents on 23 January 2013, though the sources note he initially made efforts to evade the process server, which perhaps isn't surprising.
He tried to avoid being served.
Apparently so. At the actual hearing on 28 March 2013, Costigan did not appear in court. And importantly, he had not filed any formal response or affidavit contesting the injunction application.
So he just didn't show up or fight it formally?
Correct. Ms. C.A. Webster, S.C., the senior counsel we mentioned earlier, appeared for the Bar Association. She expertly presented the evidence of Costigan's unauthorized practice to Justice Garling. She was instructed by solicitors from Hickson's lawyers who acted for the bar in this specific Supreme Court action. Because Costigan was absent and hadn't filed anything, the case was effectively uncontested in court.
But he did try to communicate his position just before the hearing, didn't he? Through an email.
Yes, he did. It was quite a revealing email. Late on 26 March 2013, just 2 days before the scheduled hearing, Costigan sent an email to the bar's solicitors, Hickson's lawyers.
What did the email say?
In it, he acknowledged again that he had no intention of renewing his practicing certificate. He again cited mental illness, specifically mentioning depression and ADHD this time as a factor. He claimed he didn't oppose being removed from the role, although this injunction proceeding wasn't actually about removing him from the role yet, just stopping the illegal practice. He detailed his dire financial situation, again bankrupt, unemployed, living on a small New Start allowance, about $533 a fortnight. And he stated he couldn't possibly pay any legal costs the court might order against him.
Okay, sounds like he was accepting the inevitable removal, maybe?
Not quite.
Because crucially, despite saying all that, he opposed the injunction itself.
He opposed the order to stop him practicing, even though he said he wouldn't practice. That doesn't make sense.
Exactly. He labeled the injunction redundant. He argued it wasn't necessary for public protection, claiming it was solely intended by the bar to set him up for future contempt of court proceedings if he ever breached it. He reiterated that same phrase. He wished only to be left alone.
So even while admitting he wouldn't practice and wasn't opposing removal, he actively fought against the court order specifically designed to stop him from practicing illegally. That shows a certain mindset, doesn't it?
It certainly demonstrates a lack of insight, as the judge later noted. He didn't seem to grasp why the bar felt a formal court order was necessary, given his recent actions.
What did Justice Garling decide about the injunction?
On 17 April 2013, the Supreme Court issued a permanent injunction against Costigan under Section 720. This order legally restrained John Bernard Costigan from engaging in legal practice in New South Wales without holding a valid practicing certificate, as required by Section 14 of the Act.
So the bar got the order they wanted.
Yes. Justice Garling carefully considered Costigan's email alongside the evidence of his unauthorized practice. He noted that Section 720 actually allows injunctions even if the person claims they don't intend to reoffend in the future. But crucially, Justice Garling found that, given Costigan's demonstrated lack of insight, particularly his argument that the injunction wasn't needed for public protection, there was indeed a real prospect that he would continue his unauthorized practice, if not formally restrained.
So the judge didn't trust his email saying he wouldn't practice.
Essentially, yes. The judge emphasized that the paramount consideration in granting such an injunction was the protection of the public, and Costigan's recent conduct and his attitude in the email indicated that protection was necessary. Justice Garling also granted those suppression orders we mentioned earlier for MH and Ms. S's identities, ensuring the published judgment focused squarely on Costigan's professional misconduct, not the private details of the unrelated AVO case.
Okay, so the injunction put a legal stop to his illegal practice. But that wasn't the end of it. The more significant step, the permanent removal from the profession, that happened in the Court of Appeal, right?
Exactly. The injunction was about stopping the immediate harm. The Court of Appeal proceedings were about the ultimate sanction, removing his name from the roll of lawyers entirely. That's the court that holds the inherent jurisdiction, the ultimate power, to regulate who is fit and proper to be an officer of the court and remain on that official list of lawyers.
So the Bar Association had to start a separate case there.
Yes. They filed a separate summons, this time at the Court of Appeal. They sought formal declarations from the court that Costigan was guilty of professional misconduct on various grounds, that he was not a fit and proper person to practice law, that he lacked good fame and character, and ultimately requesting the order that his name be removed from the roll of lawyers. This power comes partly from Section 32 of the Act, but is fundamentally preserved by Section 590, which confirms the court's inherent overarching power in these matters.
Who was involved in this final career-determining hearing? The legal teams and the judges.
The hearing took place on 22 October 2013. It is before a panel of 3 senior judges in the Court of Appeal, Justices McFarland J.A., Gleeson J.A., and Sackville A.J.
The same panel that delivered the final judgment.
Yes. Missy C.A. Webster, S.C., again appeared for the NSW Bar Association, presenting the comprehensive case for striking Costigan off, based on all the accumulated evidence of his misconduct, the financial issues, the non-disclosure, the client fund misappropriation, the illegal practice.
And Costigan's side.
Key Beasley, solicitor, appeared for Costigan, who was the respondent in these proceedings. So he had formal legal representation listed for this crucial hearing. However, as we noted, Costigan himself had not filed a substantive defense or response to the initial Supreme Court proceedings regarding the injunction, and seemed to remain largely non-engaged with the formal process overall.
What was the Court of Appeal's main task or focus in this specific hearing? It wasn't like a criminal trial, was it?
No, not at all. The court was exercising its inherent supervisory jurisdiction over the legal profession. Their primary task, as they themselves stated, was to determine, based on all the evidence of his past and recent conduct, whether John Bernard Costigan was a fit and proper person to remain on the roll of lawyers at the time of the hearing.
Fit and proper now?
Yes. And as the sources and the vast body of case law consistently emphasize, this process isn't primarily about punishing the individual lawyer for their past wrongs, although removal is obviously a severe consequence. It is fundamentally about protecting the public from anyone deemed unfit to hold that position of trust, and about maintaining the high standards and reputation of the legal profession as a whole. It also serves as a general deterrent to other lawyers.
Protection and deterrence. Okay. What was the final verdict from the Court of Appeal?
The Court of Appeal delivered its judgment on 4 December 2013. The verdict was unambiguous and decisive. They found John Bernard Costigan guilty of professional misconduct on multiple grounds, exactly as alleged by the Bar Association.
Guilty of professional misconduct.
Yes. They formally declared him not a fit and proper person to remain on the roll of lawyers, and also declared him not a person of good fame and character. And based on those findings, the court ordered that his name be removed from the roll of lawyers of the Supreme Court of NSW immediately.
Struck off. Instantly.
Instantly. The ultimate professional sanction.
And which specific grounds, which specific types of misconduct were the foundation for this final drastic step?
The judgment specifically addressed and upheld the findings on the most serious areas of his misconduct. The court confirmed he was unfit, based on these key grounds.
Okay, number 1.
First, dealing with client money, specifically the funds received from Mr. Mercer and Professor Dan, in a manner contrary to the strict rules under Section 252 of the Act. The court explicitly found this conduct was both dishonest and demonstrated a reckless disregard of his fundamental obligations as a fiduciary.
Dishonest and reckless disregard. Got it. Number 2.
Second, practicing when not entitled. This covered his appearances and actions in the Waverley Local Court in July and August 2012, pretending to be a barrister, and also his subsequent related emails where he continued to act in a legal capacity. The court found this conduct was deliberate, dishonorable, and disgraceful.
Deliberate, dishonorable, disgraceful. Okay, and number 3.
Third, his failure to notify the bar of show cause events. This encompassed his repeated failure to disclose those bankruptcy petitions over several years, and also his earlier failures to promptly report previous criminal and traffic convictions. The court found this demonstrated a reckless disregard for his clear disclosure duties under the Act and showed a consistent, unacceptable lack of candor with his regulator.
So those 3 pillars: dishonest handling of client money, deliberate illegal practice, and a pattern of hiding problems.
Exactly. These 3 key areas, supported by the extensive evidence gathered and presented by the Bar Association, formed the undeniable basis for the Court of Appeal's conclusion that he was fundamentally unfit to remain a lawyer.
So, looking at all of this together, it seems clear why he was struck off. But can we just clarify why these specific issues, particularly the misuse of funds and the unlicensed practice, were treated as the ultimate career enders, while perhaps the earlier non-disclosures or even the health issues he raised didn't, at least not initially, lead to removal?
Yeah, that's a really important point. It was absolutely the cumulative impact, yes, but crucially, it was the nature and the deliberateness of the later, more serious misconduct. While the earlier failures to disclose convictions or bankruptcy events certainly showed a problematic pattern and a lack of candor, the misuse of client funds and the blatant knowing practice while unlicensed were breaches of a completely different magnitude. They crossed fundamental lines.
Let's break down again why misusing client money is so universally viewed as completely unacceptable career-ending behavior for a lawyer.
Because it strikes right at the absolute core, the very heart of the solicitor-client or barrister-client relationship. That relationship is built entirely on a bedrock of trust, especially when it comes to handling money. Clients hand over funds, often huge sums, sometimes, as we saw with Professor Dan, their entire life savings, with the absolute implicit expectation that the lawyer will hold that money safely, use it only for the agreed legal services, and account for every single cent scrupulously.
It's a sacred trust, really.
It is. When a lawyer dips into those funds for personal use, or even just mixes them with their own money improperly, particularly before earning it or billing for it, it is seen by the courts and the entire profession as a profound, unforgivable breach of that fiduciary duty. As the court found specifically with Costigan, applying the client's money to pay his personal debts was fundamentally dishonest. This isn't a rule with shades of gray, it's black and white. Breaching it, especially dishonestly, is almost always fatal to your license to practice. End of story.
And the second major factor, the killer blow, was ignoring the ban and continuing to practice.
Absolutely. This wasn't an accident, a misunderstanding. He knew his certificate was suspended. He knew it was then canceled. He knew he had chosen not to renew it. He'd even told the bar he wasn't going to practice. Yet, he deliberately walked into court, dressed the part, and pretended to be a licensed barrister.
It's breathtaking, really.
It is. This is more than just a rule breach. As we said, it's illegal conduct. It's a knowing, willful defiance of the law he swore an oath to uphold, and it's a contemptuous defiance of the regulatory system designed specifically to protect the public. And his subsequent lies to MH, to the court staff, They just compounded this significantly. It showed in the Court of Appeal's own words that his conduct was disgraceful and dishonorable. It speaks to a deep fundamental lack of integrity and this dangerous belief that the rules simply didn't apply to him.
And there's precedent for this specific issue, too.
Oh yes, as established clearly in precedent cases like NSW Barrister v. Perry, deliberately practicing law when you know you are suspended or canceled is considered so fundamentally incompatible with the character required of a lawyer that it, by itself, can destroy any claim to fitness to practice.
Okay. What about that earlier pattern of non-disclosure, hiding the bankruptcies, hiding the convictions? Did that contribute directly to the strike-off decision itself, or was it more about establishing his character, his lack of candor, leading up to the final breaches?
It absolutely contributed, yes, primarily because it demonstrated that consistent long-term lack of candor and transparency with his professional body. While some of the earlier convictions themselves viewed alone might not have led to strike-off, the repeated failure to disclose them, combined with repeatedly hiding the bankruptcy petitions, that revealed a deeply troubling pattern of behavior over many years.
The hiding was as bad as the events themselves.
In legal ethics, often yes. The attempt to conceal problems frequently carries more weight in disciplinary hearings than the initial issue itself, especially if the initial issue wasn't inherently dishonest. By hiding these significant events, Costigan lost any chance he might have had to demonstrate to the court or the Bar Association that he was someone who could be trusted, someone who could learn from mistakes, or someone who possessed the basic honesty required to self-report issues as the rules demand. It completely destroyed his credibility long before the final hearing.
Now, Costigan himself brought up his mental health issues as part of his explanation, or maybe mitigation, for his conduct. How did the court weigh that factor in their final decision to strike him off?
The sources, particularly the Court of Appeal judgment, acknowledge his claims of mental health issues. They specifically cite his references over time to anxiety, PTSD, depression, and ADHD. And it's important to remember, as we discussed, that the NSW Bar Association had previously engaged with these concerns.
They knew about them.
Yes. They had ordered that medical examination by Dr. Alex Wodak back in 2010. They had imposed conditions on his certificate in both 2010 and 2011, attempting, it seems, a kind of rehabilitative approach to support him in practice while managing these issues.
So they tried to help him manage?
It appears so. However, when it came to the later deliberate acts of dishonesty specifically, misusing client funds and then practicing illegally while knowing he was banned, the Court of Appeal was very clear in its judgment. While personal issues, including health conditions, might provide some context or explanation for why a lawyer might be struggling, they do not excuse deliberate dishonest conduct or willful breaches of fundamental professional obligations.
So even if he was unwell, he still knew what he was doing was wrong.
That's the essential finding. As Justice Sackville AJA observed carefully in the Court of Appeal judgment, even when facing personal difficulties, a lawyer is presumed and required to understand the difference between right and wrong, and to understand their paramount duty to the law, the court, and their clients.
Mental health isn't a get-out-of-jail-free card for dishonesty.
Precisely. While seeking help early for struggles like financial pressure, health issues, or addiction is strongly encouraged by the profession and can be viewed favorably if disclosed properly. Organizations like BarCare exist specifically for this confidential support. After the fact, pleas of illness or distress simply could not excuse his willful and dishonest actions in misusing client funds and practicing illegally. At the disciplinary stage, the court's primary focus inevitably shifted from any potential for rehabilitation to the overriding necessity of protecting the public and maintaining the integrity of the entire profession.
So the ultimate decision to strike him off the roll wasn't some kind of anomaly or overly harsh reaction. It was actually consistent with how courts in New South Wales, and indeed across most common law jurisdictions, handle such grave professional misconduct.
Absolutely. The sources and the judgment itself emphasize how Costigan's case aligns perfectly with long-established legal authority. Those cases we mentioned earlier, Cummins on the importance of trust, Hammond dealing with dishonesty in client funds, Perry on the severity of practicing without entitlement, Kearns regarding patterns of disregard for law and convictions, and McCaffrey on dishonorable conduct, they all illustrate the well-established principles that were applied directly in Costigan's case.
So the rules are clear, the precedents are there.
Very much so. Client-related dishonesty, deliberate rule-breaking, especially defying a ban, deceiving the court or the regulator, and a demonstrated pattern of disregard for legal and professional obligations. These are well-established grounds for permanent removal from the role of lawyers.
It sends a clear, consistent, and necessary signal that the profession, through the courts and its regulatory bodies like the Bar Association, polices itself rigorously to maintain the highest standards for the protection of the public.
This whole case, it just feels incredibly important, not just as a historical account of one man's downfall, but as a really potent warning for anyone involved in the legal world, particularly those just starting their journey, maybe law students or junior lawyers or barristers. What are the absolute key cautionary lessons we can pull from John Bernard Costigan's tragic fall?
There are so many, but let's focus on the most critical ones. The first, and perhaps the most fundamental lesson of all, is that ethics and integrity are not optional extras. They are the absolute bedrock of your profession. They are non-negotiable.
More important than being clever or a good speaker.
Absolutely. Technical legal skill, brilliance in argument, courtroom presence. None of that, absolutely none of it, can compensate for a fundamental lack of honesty and integrity. As a lawyer, your reputation for trustworthiness is your single most valuable asset. Compromising it, especially through acts of dishonesty like misusing client funds, lying to the court, or deceiving the regulator, it sets you on an almost irreversible path towards professional ruin. Trust, once it's lost, is monumentally difficult, sometimes completely impossible to regain.
And that trust begins, really, the moment a client entrusts you with their money.
Absolutely, which leads directly to the second crucial lesson. Client funds are sacred and subject to incredibly stringent rules. Never, ever, under any circumstances, intermingle client money with your own or misuse it for your personal needs or even the running costs of your practice. You must understand the incredibly strict rules around receiving advance payments, particularly for barristers, under the relevant sections of the Act and regulations, like S-252 and CL 106A.
Ignorance is no excuse.
None whatsoever. Costigan's case is a stark, brutal illustration of the severe career-ending consequences of crossing this line. It's worth noting that most barristers in Australia actually choose to avoid holding client money directly precisely to eliminate any potential temptation or risk. They prefer funds to be held securely in a solicitor's trust account, where the rules and oversight are equally strict. This case powerfully demonstrates why that boundary is so vitally important.
Okay, lesson 3. Your practicing certificate, that license to practice. It's more than just a piece of paper you renew every year, isn't it?
Far more. The third lesson is, your practicing certificate is your license to operate. It is your permission slip from the community and the courts to practice law. Practicing without one, as Costigan did so brazenly, is not a minor administrative oversight. It is a legal conduct, full stop. And it's treated by the courts as a grave offense that destroys any claim you might have to fitness to practice. If your certificate is ever suspended or canceled for any reason, you must cease practice immediately and completely. Don't try to fudge it. Don't be, in the words sometimes used in commentary on cases like this, an imposter in a wig. Knowing defiance in this area is absolutely career-ending.
Transparency with the professional body, the Bar Association, or Law Society. That sounds like it was a massive failure point for him over many years.
It absolutely was. Which brings us to the fourth lesson. Be transparent and forthright with your regulators. Always. Promptly disclose show-cause events like bankruptcy petitions or certain convictions, exactly as required by the legislation. 67 is 55. Costigan's consistent pattern of hiding significant issues did not protect him in the long run. It only made his situation exponentially worse when everything inevitably came to light, and it completely eroded any credibility he might have had left.
Hiding just digs a deeper hole.
Precisely. The professional bodies exist to regulate, yes, but they also often have support structures in place. The cost of candor disclosing problems early so they can potentially be managed or addressed with support, perhaps through conditions or health programs, is infinitely less than the cost of deceit when you are inevitably discovered later.
You mentioned personal struggles throughout, health issues, financial problems. What's the lesson there for others facing difficulties?
That leads straight into the fifth lesson, and it's a crucial one for well-being in a demanding profession. Seek help early if you are facing personal, financial, or health struggles. Do not let these problems fester and spiral out of control until they lead you to consider or commit ethical breaches, as they so clearly did in Costigan's case.
Don't wait until it's too late.
Exactly. The pressures of legal practice can be absolutely immense. Confidential counseling services, financial advice, health support networks, these are available through professional bodies, like Bar Care and NSW, for example, and other avenues. Seeking help before you cross ethical lines, before desperation leads to dishonest acts like dipping into client funds, is absolutely vital. As the court found, while personal difficulties might provide context, they do not excuse deliberate misconduct after the fact. Get help when you first need it.
not after the damage is done.
And finally, it seems your integrity isn't just about what you do in court or in your office hours. It extends to your whole life.
Not at all. The sixth lesson, reinforcing the fit and proper person test. Your personal integrity matters, not just your professional conduct. Convictions, even for seemingly minor matters like traffic offenses, if they form a pattern or show disregard for the law, can impact your assessed fitness to practice, particularly if they reveal dishonesty or, crucially, if they are hidden from the regulator. As officers of the court and guardians of the law, lawyers are expected by the courts, the profession, and the public to uphold the law and demonstrate good character in their private lives as well as their professional ones.
So ultimately, putting it all together, John Bernard Costigan's story is just this stark, undeniable, and frankly tragic reminder that personal and professional integrity are completely intertwined. Compromise in one area can very quickly lead to absolute ruin in the other.
It is. It serves as a powerful and deeply cautionary tale that integrity must always, always come before short-term pressures, perceived needs, convenience, or ego. Trying to fix financial problems by secretly dipping into client money or continuing to practice illegally because you don't want to face the consequences of losing your license. These are short-sighted, fundamentally dishonest acts with utterly devastating long-term consequences. Don't let ego, pressure, desperation, or greed lead you down that path of deception.
It's a slippery slope.
A very slippery slope. A legal career, especially one at the bar like Costigan's, is built on enduring principles: honesty, trust, service to justice, duty to the court. Betraying those core principles, as Costigan did on multiple fronts, financially, ethically, legally, leads, almost inevitably it seems, to a tragic and public downfall like his.
So wrapping up this deep dive, we've really traced John Bernard Costigan's path. From being admitted as a barrister way back in 1989, through those years of mounting hidden debt and accumulating professional lapses.
The undisclosed bankruptcies, the hidden convictions, the health issues.
Right. Leading to the desperate, dishonest acts of misusing substantial client funds from the Mercers and Professor Dan, and then the ultimate defiance of practicing illegally after his certificate was canceled.
Appearing in Waverley Court, lying to court staff.
Which culminated in the NSW Bar Association, represented so effectively by Ms. C.A. Webster SC and solicitors Hickson's lawyers, taking necessary action. First, through the Supreme Court to stop his illegal practice with that injunction granted by Justice Garling.
And then the final step in the Court of Appeal. Before Justices McFarland J.A., Gleason J.A., and Sackville A.J., represented again by Mrs. Webster SC for the bar, and with P. Beasley, solicitor, appearing for Costigan.
Where the court found him guilty of professional misconduct, dishonesty with client funds, illegal practice, lack of candor, declared him unfit, and ordered his name be removed from the roll of lawyers entirely.
His name was struck off the roll of lawyers of the Supreme Court of New South Wales. And barring truly extraordinary and frankly highly unlikely circumstances that might permit a successful application for readmission many years down the line, which is incredibly difficult after findings of dishonesty. His career at the bar is definitively over.
Yeah.
A professional life that spanned over 2 decades ended not in honorable retirement or a quiet transition, but in public disgrace, cemented by published court judgments detailing his fundamental unfitness to be a lawyer.
The legacy of this case, though, it's profound and it's enduring. It isn't just gathering dust in the law reports somewhere.
No, definitely not.
Yeah.
Costigan's case serves as a stark, modern, and frequently cited example. It's discussed regularly in legal ethics courses, used by regulators as a clear precedent demonstrating the severe consequences of breaching core professional duties. It powerfully demonstrates the profession's commitment, through the actions of the Bar Association and the courts, to policing itself rigorously, to protect the public and maintain its essential integrity, even when faced with the difficult or complex personal circumstances of the practitioner involved.
Costigan's story, alongside other prominent disciplinary cases, really reinforces that fundamental principle, doesn't it? That the privilege of practicing law is this profound responsibility. It's conditional on maintaining absolute good character and upholding the highest ethical standards at all times.
Absolutely. It's not a right. It's a privilege earned and maintained through conduct.
And if we connect all of this back to why any of it matters to you, the listener, what does it truly mean? Or perhaps more importantly, what should it mean to wear the wig and down, or simply to hold that license to practice law? It represents really the immense, sometimes quite overwhelming trust placed in you. Trust from your clients who are often vulnerable, maybe scared, entrusting you with their most sensitive matters, their livelihoods, their liberty, and sometimes, as we saw with Professor Dan, their entire life savings. Trust from the courts, who rely implicitly on your honesty, your candor, your adherence to the rules to administer justice fairly and efficiently. And trust from your colleagues, the other lawyers you deal with, who depend on your word and your ethical conduct to make the system work.
The whole ecosystem of trust.
It is. And John Bernard Costigan's case is just this tragic, unavoidable reminder of the immense weight of that trust and the absolute, non-negotiable necessity of safeguarding it at all costs. Because when that trust is broken, as his story shows so vividly, the consequences are not just professional, they are profoundly personal and often irrevocably final.
It really leaves us with a crucial question to reflect on, doesn't it? For anyone in the profession or thinking of joining it, how do you as an individual navigating the inevitable pressures of professional life? The stress, the deadlines, the financial worries, the difficult clients, maybe personal struggles?
Yeah.
How do you ensure that the desire to succeed, the pressure to solve problems quickly, or even just basic human difficulties never, ever overrides that absolute requirement to act with unwavering honesty and integrity? What internal principles, what personal boundaries, and what external support systems are essential to build and maintain throughout your career to ensure you never find yourself starting down a path that could lead, even incrementally, to the kind of tragic downfall we spent this deep dive discussing today?
A question that should resonate very deeply with anyone who holds or ever aspires to hold that immense privilege of being a lawyer. Thanks for joining us for this deep dive into what is truly a sobering and cautionary tale.